Hello and welcome back to Yada Yada Law School, a fake law school where real law professors teach classes about nothing for charity. As a reminder for those just tuning in, you can find a link to the donation page for our charity partner, the COVID-19 Relief Fund of Legal Services of New York City, in the Q&A tool in Zoom, or on our website, yadayadalawschool.com. When we came up with the idea of Yada Yada Law School in the spring, New York was the epicenter of the global pandemic. That is fortunately no longer the case today in late July, but the economic hardship there continues to be widespread and pronounced and is perhaps only becoming more so. So we're so grateful for the contributions we've received so far for the COVID-19 Relief Fund. And if you haven't had a chance yet to chip in this week, we would encourage you to do so now. Speaking of New York City, here to teach our next class, Seinfeld Civil Procedure, is Professor Robin J. Effron, the Newman USPS Professor of Law at Yada Yada Law School and a Professor of Law at Brooklyn Law School. Please be sure to use the Q&A tool in Zoom to submit your questions for Professor Effron. Questions will be moderated by Professor Guha Krishnamurthy, the Jacopo J. Peterman Chair in Jurisprudence and Fashion Design at Yada Yada Law School, Clemenco Fellow at Harvard Law School, and an Assistant Professor at South Texas College of Law. Professor Effron, over to you for Seinfeld Civil Procedure.
All right, great. Thank you so much. I'm so happy to be here. This is the donation site again. It's been mentioned several times today, but we are pretty close to our goal, and we would really encourage everyone to donate if you haven't gotten a chance to do so yet. So I am Robin Effron. I teach at Brooklyn Law School, and I teach mostly civil procedure, but I do teach some business and contract law courses. So I will give you just a quick Easter egg at some point in the lecture today, a little bit of that information as well. But here's where we're going to start, which is, what is civil procedure? So, when we're thinking about how a show like Seinfeld has to do with different areas of law, it can seem really obvious. And as I was thinking, I came up with a million examples for contracts and property and even areas of law that I don't study, like criminal law. But typically in TV, unless it is a show about lawyers, or unless the characters are actually filing a lawsuit and going to court, you don't really see a lot of civil procedure. That being said, I think we can actually learn a lot about procedural concepts from some of the things that went on in Seinfeld, and that's what I'm going to show you today. So let's start with what civil procedure is. So civil procedure is the study of rules and systems that facilitate and support civil dispute resolution. So these can be federal, state, and local courts, right, if we're talking about here in the United States, or even alternative forms for dispute resolution. So arbitration, mediation, collaborative law, and informal negotiation. These are all actually part of civil procedure. And one of the things that you would also learn about in a civil procedure class is the study of the allocation of power among and between these courts and systems. And so we're going to have a chance to talk a little bit about both of those today, some of the rules that go into civil procedure, but also some of these power dynamics. So we are going to start with one of my favorite episodes of all time, which is The Deal. Right, so this is season 2, episode 9. It's pretty early in the series. And if you recall, one of the premises of the show is that Jerry and Elaine had once been romantically involved, but they no longer are. They are just friends. But then sometime around season 2, the writers decided that they needed to spice things up and see if they could get Jerry and Elaine involved again. And it turns out that for an episode that is called The Deal, and you might therefore think it's about like contract law or other sorts of agreements, there is in fact a festivus of civil procedure issues in this episode. So let's start with some basic ones like jurisdiction, choice of forum, and choice of law. So here's the setup. Right, so what happens is that Jerry and Elaine are sitting around in Jerry's apartment, and some interesting television comes on the screen. It makes them think about a few things. And they start to talk about, well, why can't they just have a sexual relationship, but also a friendship, right? So why can't, we didn't have the phrase back then. Basically, they're saying, why can't we set up a friends with benefits situation here? And so Jerry says, why shouldn't we be able to do that once in a while if we want to? Elaine says, I know. And here's where we get to our civil procedure issues, right? So Jerry says, I mean, really, what's the big deal? We go in there, right? And he points to the bedroom. We're in there for a while. We come back out here. It's not complicated. And Elaine says, it's almost stupid if we didn't, which is, of course, the beginning of every bad contract and every start of a TV show. So this is what the idea is, right? So we get the pointing, right? Jerry says, because this is very good. And Elaine says, and that would be good. That would be good too. And here we get some of the procedure. The idea is to combine this and that, but this cannot be disturbed. And Elaine says, yeah, we just want to take this and add that. Okay, so what does this have to do with civil procedure? What we're going to learn over the next few minutes is that it's basically the question of, can they really do this? Can you have one set of rules for in there and another set of rules for out here and actually make it work, right? And even though this is sort of a silly setup for a friends with benefits situation, it turns out that a tremendous amount of law and civil procedure is trying to answer exactly that question. Can we have one set of rules for over here and another set of rules for over there, and then try to resolve disputes in a single place and figure out what's going on? So immediately they come upon an idea, which is they start to sense maybe this could be problematic, right? So they set up some rules, right? Jerry says, but of course we'd have to figure out a way to avoid the things that cause the little problems, maybe some rules or something. All right, so let's take a look at the rules that they set up. And we're gonna learn a little bit about legal rules and especially how they fit into civil procedure. So here's the first rule, right? Well, for example, I call you whenever I'm inclined and vice versa, right? But if we did that, we might feel a certain obligation to call. Elaine, well, why should that be? Oh, I have an idea. No call the day after. Jerry says, beautiful, let's make it a rule, right? So that's rule number one. Now, the second rule, right, they start to wonder, oh man, it's this thing. People expect to sleep over afterwards, but we're just friends with benefits, right? So they come on the second rule, and Elaine says, oh, okay. Spending the night is optional. And then by the time we get to the third rule, it's like hardly even a rule, right? Elaine says, what about the kiss goodnight? Tough one, your call. And Elaine just says, it's bourgeois. So let's talk about what kind of rules these are, right? So here are Jerry and Elaine's rules. So the first one, that's a rule, right? It's no call the next day. We understand what it means, right? You could have some interpretive questions, right? These days we might wonder, like, does no call the next day mean no text the next day? But it's a rule, right? It's not a standard. The second one, sleeping over is optional. Well, here we've left some option for later discretion. And that's actually a big part of civil procedure and procedural rules. There are many procedural rules that leave things open, in particular for a judge to decide, right? And sometimes we think of that as being really good, right? We allow judges to manage the litigation of cases based on their wisdom and experience. And sometimes it's not such a great idea to leave things open for later discretion, because it turns out that maybe you didn't really intend for someone to have discretion. You just didn't want to make a decision in the first place. And there are plenty of rules and statutes that look like that, right? That it looks like we want to enable discretion, but if you kind of peek behind things, really it's just Congress or rule makers kicking the can down the road and saying, well, we couldn't come up with an answer, so we just hope that individual judges will. And then finally, what kind of a rule is this? A kiss goodnight is bourgeois. Maybe it's a standard, Not really a standard, right? A standard is something like, for example, if a rule says the speed limit is 55 miles an hour, a standard might say you should drive at a reasonable pace on the highway, right? That would be a standard where you don't give an exact number, but people more or less know what you mean, right? Kiss goodnight is bourgeois. Is that enough information? Probably not. And it's interesting, you can see their rules kind of go from like, we're going to have really great clear rules, and then it kind of devolves from there. Okay, so let's start to talk about the jurisdictional issues, right? Different jurisdictions have different laws. And this is what Jerry and Elaine are trying to set up, right? They're trying to sort of divide up their lives into these tiny little jurisdictions, right? The jurisdiction of the bedroom and the jurisdiction of out here. And so jurisdiction is power, right? It's the power that a state or a forum exacts over the people or of the things within it. And of course, that becomes very difficult very quickly because people and things move in and out of borders all the time. And there are plenty of things that it's hard to sort of locate within borders. And there are two types of jurisdiction that are going to be important for us. One is adjudicative jurisdiction. That just means when does a forum have the power over parties or things to decide disputes in its courts. And in the US, we think a lot about subject matter jurisdiction, which is the power of the court to hear a type of case, and personal jurisdiction, which is the power of the court over the parties or things to be adjudicated. And then there's prescriptive jurisdiction. This is the power of a state to make applicable laws. And so here, we can kind of think about the Jerry and Elaine situation in both senses, right? What kind of power have they allocated to themselves or to these different rooms, both to make rules, right? Can we have actual different rules in each of the different rooms? And also it's going to come up in the episode how they're going to decide when something has gone wrong, right? And that's adjudicative jurisdiction. So why do litigants care about jurisdiction and forum? Well, I think the episode teaches us a lot about that, right? If you can set up a system in which there are different places that have different laws, then what ends up happening is that people and businesses can take advantage of that, right? They can say, I want one set of rules for in there and one set of rules for out here, right? I would like the tax rules of over there, and I would like the business association rules for over here, right? And so that's what a lot of people do. They try to exploit these differences between the laws of different jurisdictions, and that is what Jerry and Elaine are trying to do here. So let's talk about forum and jurisdiction, right? So parties can often choose where they'd like to be legally speaking, right? You can often decide where your residence is going to be, right? Or where your business operations are. Or if you're a business, maybe you want to have most of your business operations in one state and your place of incorporation in another state. Now, another way that you can do this is by contract, right? And this is in some ways what Jerry and Elaine are doing, right? They can specify in advance that a forum will hear disputes that arise out of a particular situation. And here I've given you two Supreme Court cases that basically ratified this practice, that said it's okay, right? You could have no connection to a forum whatsoever, right? Jerry and Elaine could decide if a dispute arises out of our relationship, we designate the random family 5 blocks away. That will be the forum where we decide our dispute. They don't have to have any connection to it whatsoever, as long as they have knowingly and voluntarily consented to adjudication in that forum. That's fine, according to the US Supreme Court. You can also choose law, right? So choice of law is part of a larger field called conflicts of law, which is the whole question of how courts know what law to apply to different parts of a dispute. And choice of law is the part where we wonder, can parties choose this for themselves? And the answer is yes, choice is possible. They can, with very, very few limitations, choose whatever law they want to apply in a dispute that rises out of an agreement that has a choice of law clause. And the choices are so many. You can choose state law, federal law, foreign law, or even this thing called non-state law, which is basically private organizations that get together and write little mini statutes that haven't been enacted anywhere, but people can choose to be the law of a given transaction or other situation that they're in. And also, you can mix and match, right? So it is possible to choose different sets of laws for different circumstances. So we really could have rules for in there and rules for out here. And another way that you can mix and match is that you could make a contract that chooses one jurisdiction as the forum for dispute resolution and another one to supply applicable law. So for example, you could say, if a dispute arises, we will resolve it according to the laws of Jerry's apartment, but we want the laws of Elaine's apartment to supply the actual rules of decision in our case. So that leads us into horizontal and vertical choice of law. So Jerry and Elaine have established basically a horizontal choice of law scheme here. That means that there are many different laws or sets of laws that could be applied to their underlying conduct, right? The rules for their sexual relationship and the rules for their friendship. So that's the one set of rules for in here and another set of rules for out there. But they forgot about procedure, and this is going to come back and bite them. So in the US, we have horizontal and vertical choice of law questions. So horizontal is the one that I just described to you. Vertical is the question of when you're in federal court, although this can also happen in state court, and you're hearing a case that involves certain claims, should that federal court apply federal law or state or some other law? So part of this answer is easy, right? So for the law of the claims themselves, a federal court should use the underlying state law for traditionally state law causes of action. So if you're in federal court, but the case that you're bringing is a contracts case or torts or property, unless this is admiralty law or something like that, you're going to be applying state law. And that's the case of Erie versus Tompkins. But then the question becomes, do federal courts also have to apply state procedural law in these cases, right? So we know that if we're asking the question, is a contract enforceable? We're going to look at underlying state law. But then what about questions of how the court is going to operate or what rules of evidence they're going to use? Do you use the New York rules of evidence, even if it's a federal court sitting in Massachusetts? And that's what this Erie doctrine is really about, right? When people study it in law school, is what are you going to apply? Right, so how does this apply here? Here we have Elaine in her apartment. Remember how Jerry and Elaine hadn't really decided on the kiss goodnight rule, right? They just said, oh, kiss goodnight, that's bourgeois. So later in the episode, Jerry tries to kiss Elaine goodnight, but we're in her house, right? So she makes the rules, right? They get in a little bit of a kerfuffle about what does the rule mean, who gets to interpret, right? And she says, hey, my house, my rules. So she's right here. It's her forum, so we're going to follow her procedural rules. And in fact, that is what the US Supreme Court has said as well in a case called Claxon versus Stentor. So that's the Erie doctrine. Now, I promised you a bonus contracts lesson, and I'm going to give that to you here. So part of this episode involves a scenario where Jerry has to buy Elaine a birthday present, right? And like many romantic or sexual partners, he can't figure out what she really wants. And he's really nervous about this now that they're back in this relationship. So after hemming and hawing, he finally decides to get her cash, and he wraps it up in a box. And of course, Elaine opens up the box and she's kind of horrified and offended. And so the question is, should we be surprised at this? And this actually gets to a really deep question in contract theory and property theory, right? Is there a difference between gifts and transactions? And I just wanted to point out for you some interesting research on that topic, especially that second article, which is that at least one economist sides with Jerry, This guy wrote an article called The Dead Weight Loss of Christmas, in which he basically argued that everyone should just get everyone else gift cards because there's just a lot of economic waste in gift giving. But you can see that Elaine's reaction suggests otherwise, that there is an effective quality to gift giving. Okay, I've had enough of my non-civ pro moment in there. We're going to move on to some other interesting lessons out of the deal. Parties bound by a judgment. So later in the episode, things have really gone south between Jerry and Elaine, and not only have they broken off the sexual relationship, but they've decided that they can't be friends either, right? So don't worry, right? They end up reconciling by the end of the episode. But of course, when Jerry discusses this with George, George is worried mostly about himself. And George says, you know what this means? I can't see her anymore either. And Jerry says, why? And George says, it's breakup by association. So the question is George right here, right? Is George bound by the judgment, right? By the finality of the ending of Jerry and Elaine's relationship? So let's take a look at the law of what happens when we want to know if parties are bound by a judgment. So in general, a person or entity can only be bound by a judgment if they were a party to the lawsuit. That's actually a constitutional issue. It comes to us from the 14th Amendment, right? It would be a violation of due process of law to bind you to a judgment where you did not have notice and opportunity to be heard. And so the Supreme Court confronted this in a number of cases, right? The most recent one is a case called Taylor versus Sturgill. It's a great Ginsburg opinion. Now, there are some exceptions. So for example, absent class members in a class action don't have to actually be there. They can be bound by a judgment. And we have long and complicated rules about how class actions are prosecuted. And one of the reasons is that it's supposed to protect absent class members, that we want to be very careful before we bind people to a judgment. But outside of that, right, there's another number of categories of exceptions. But what it comes down to is that unless the parties are in privity, meaning they have a contractual relationship of a very certain type, or there are some serious procedural protections of the non-party in the first actions, a non-party cannot be bound. So here, Jerry had different interests than George, right? When Jerry is figuring out what he wants his relationship to be with Elaine, he's doing it as someone who had once dated her and then had tried to resume this sexual relationship with her and maintain a friendship, right? George was in a very different position from Jerry. So we would say that Jerry was not a good proxy for George, right? When Jerry is making a decision about whether that relationship should continue, he's in a very different position from George. So under Taylor versus Sturgill and a whole bunch of other cases, we would say George is free to maintain his friendship with Elaine. So that is pretty much all I have to say about the episode, The Deal, right? As you can see, just a mountain of procedural issues there. But what I'm going to move on to now are two more episodes where we're going to talk less about jurisdiction and power and the overall system and more about the nitty-gritty of civil procedure. So we're going to talk about the dinner party and the soup Nazi. And then in a few minutes, I'm going to add the episode, The Gymnast, which is the eclair out of the garbage episode, if you are wondering. Okay, so let's talk about commencing an action and also this concept of procedural formalism. So commencing an action, that basically means, how do you start a lawsuit? What are the rules for doing it? And you can't just sort of show up in court and be like, hey, I'm here, I think this person was wrong and I would like money. You actually have to jump through a lot of important procedural hoops to make sure that the other side knows that you are suing them, that you have a meaningful claim, and lots of other things. And we're going to talk about those here. So let's talk about the setup. We'll actually take 2 episodes at a time here. So Seinfeld as a show is actually very good at portraying small businesses in which patrons must adhere to elaborate procedures and rituals in order to be served. So if you recall, in the episode about the dinner party, Jerry and Elaine and Kramer and George, who are not in the picture there, are all going to a dinner party and they have to bring something, and they decide they're going to bring the chocolate babka. So they go to the bakery. But when they get to the bakery, they forgot to take a number that sets things in motion. And I think pretty much everyone watching this webinar right now remembers the soup Nazi, right? This guy has just sort of transcended Seinfeld and kind of come into pop culture altogether as this soup proprietor who demanded sort of this ritualistic adherence to how one orders and receives soup in his shop. And if you do not follow his rules, then you get kicked out and no soup for you. Okay, so we're going to talk about that in terms of commencing an action and pleading. So here we have the rules for the chocolate babka, right? And so Elaine realizes that they forgot to pick a number, right? And she sort of points out that there's a little bit of unfairness here, right? Like, why is it that the bakery is going to insist on standing on ceremony with these numbers, right? Everyone can see that we came in first, we came in before all of these other people. And so she's kind of making what we would call an equitable argument about the fairness of the situation. But unfortunately for them, right, they didn't take the number and they are not able to prevail upon the people in front of them who get the last chocolate babka, who go to the dinner party, right? It's a different part of the episode. And then in the soup Nazi, right, here we have only a part of the ritual, right? Well, you have to follow the procedure, okay? You walk in the place and move immediately to the right, and then you hold out your money and speak your soup in a loud, clear voice, step to the left and receive, right? And if you sort of mess up any of these steps, you're going to go by the wayside. So different jurisdictions have different rules, but they all have procedures and formalities that must be followed in order to get in the door in federal court. So one of the things that Seinfeld is a good illustration of is that things were much worse actually in the old days. So before the late 1930s, in federal court, and certainly in the 19th century in many state courts, there were very elaborate, I would even say soup Nazi-esque procedures for commencing an action in court. And if you as a litigant messed up at any step along the way, that was the end of your lawsuit, right? You were out of there. That was the end. And one of the things that happened as we moved from the late 19th century into the early 20th century is that a lot of judges and commentators started to think that we needed some procedural reforms, right? That the procedure had sort of overtaken the substance. It didn't make a lot of sense to have people who had otherwise completely good claims, right? What we would call meritorious claims. And suddenly they were left with no relief and no ability to sue the other side because they messed up somehow, right? They wrote the wrong word down on a piece of paper. It was actually a breach of contract, but they called it a tort or something like that. They used the wrong language. They gave the slip of paper to the wrong person. They messed up in some small timing way, right? These were all things that could slip you up in the old days. And so now we've moved into a system in which there are lots of hoops to jump through, but it's a lot more forgiving, right? So in most cases these days, you still have to follow all of those rules, right? You still have to commence an action in a way that the court says you have to commence an action. You still have to file papers in the way that the court says you have to file papers. But for the most part, innocent mistakes are remediable in court, right? So if you mess up, then for the most part, you'll be able to sort of go back and have a do-over and start again. But there are still some parallels. So in federal court, for example, you have to what's called file your complaint before you serve it, right? So you actually have to start the action in court and then you go off and serve the other parties. In some state courts, it's actually the opposite, right? You serve the other parties and then you go to court and you file the complaint. But in federal court, you have to kind of go and take your ticket, right? You go to federal court, they give you a docket number, that you put on your summons. Now you have your summons, you take that along with your complaint and you serve the other party. And so why does this matter, right? The federal courts aren't going to run out of judges like the bakery runs out of chocolate babka. And as I mentioned before, many of the mistakes that used to just be like no soup for you in the old days, these are mistakes that parties are able to fix. Well, in some senses, though, you might be out of luck. So, for example, if the statute of limitations has run in between when you make a mistake and you have to start over again, in certain circumstances, that can actually prevent a litigant from being able to properly refile or recommence an action. And there are some other procedural barriers that can get in the way as well. So even though we live probably more in the world of chocolate babka than we do in the world of soup Nazi, it's still important either way to make sure that you mind all of your procedural P's and Q's, but we can all be thankful that we no longer live under the field code or these other 19th century procedural regimes. So the last thing that I want to talk about are some of the formal requirements of pleading. Right, so here we're going to learn about pleading in soup. We're going to dip into the soup Nazi a little bit more, and we're going to see that what is the standard for having things in a complaint. So in federal court, right, in order to have a lawsuit, you have to file a complaint. You actually have to show the court and the other side that I think the other side has wronged me, and I have a legal basis under which relief can be granted, right? And this is found in federal court in Rule 8A2, right? It requires that a pleading state a claim for relief must contain a short and plain statement of the claim showing that the pleader is entitled to relief. So here, right, we kind of see this in the soup Nazi scene, right? So hold out your money, speak your soup in a loud, clear voice, step to the left and receive. And Jerry kind of adds, right, it's very important not to embellish on your order. No extraneous comments, no questions, no compliments. This is actually a thing that exists in federal court, right? So most of the litigation about the adequacy of pleading has to do with whether the complainant has not said enough, and we'll talk about that in a second. But it is possible to say too much or say it in the wrong way, and that is called prolixity, right? And if you run afoul of that Rule 8A2 command to give a short and plain statement of relief, then the court can do things like strike certain parts of your complaint, and in sort of really extreme scenarios, send you home and make you start again. So let's talk about the contents of the complaint, right? That was sort of the formal requirement. And here's where we're going to move to our very last episode of the day, which is the gymnast, right? So let's talk about the setup here. So George is trying to impress his girlfriend's mother with his excellent manners when he's invited over for lunch. But then he goes into the kitchen and she catches him eating a chocolate eclair from out of the garbage. So the question is, was George eating garbage? And let's talk about that in the context of pleading, right? So here we have a pleading standard from Twombly and Iqbal, two pretty famous cases from about 10 to 15 years ago. And what the Supreme Court said here is that when we're deciding if the plaintiff has said enough, we're going to ask for the plaintiff to allege enough so that the court thinks it is plausible that the plaintiff is entitled to relief. So I've put up the key language from the Iqbal opinion here. To survive a motion to dismiss, a complaint must contain sufficient factual matter, except it is true, to state a claim for relief that is plausible on its face. Right? And so what we get when we go kind of further down into this language is that we want the court to be able to draw the reasonable inference that the defendant is liable for his misconduct. And so what you can see here is that pleading is actually part of a much larger set of legal concepts and issues, which is, when do we allow people to draw inferences from certain sets of facts, right? There are all sorts of questions in evidence, for example, that have to do with permissible inferences. There are questions about who gets to draw inferences, right? Is it a judge? Is it a jury? But here we want to know, right, if we're trying to figure out, is this garbage, right? Is that a reasonable inference from what was going on there, right? So let's fast forward a little bit later in the episode to the explanation, right? So here, Jerry is kind of like going over the situation with George after it happened. Jerry says, so let me get this straight. You find yourself in the kitchen, you see an eclair in the receptacle, and you think to yourself, what the hell? I'll just eat some trash. And George is like, no, 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 no. It was not trash. So now we're going to start to have Jerry ask George the questions that we should be asking ourselves when we're figuring out whether or not this is a plausible inference. Jerry says, was it in the trash? George says, yes. And Jerry says, then it was trash. Okay, so that's often where we would start with this sort of pleading inquiry, right? So what is our baseline expectation for behavior or conduct or a certain state of affairs, right? And so I would say that Jerry is not incorrect, right? Like a pretty good starting place is to say, if something is in the trash, then it's probably trash. But George is going to try to kind of like push back against this inference. And he was like, it wasn't down in, it was sort of on top. And Jerry's like, but it's in the trash. George says above the rim. And Jerry says, adjacent to refuse is refuse. And George says it was on a magazine and it still had the doily on. Was it eaten? One little bite. Well, that's garbage. And George says, but I know who took the bite. It was her aunt, right? So at the end of the day, the question then is this trash? Now, importantly for pleading, George doesn't have to prove anything, nor does Jerry at this point. When a court is deciding the question of pleading and whether a complaint is going to survive a motion to dismiss, it accepts all of the facts in the complaint as true and then says, even accepting all of these as true, does it amount to the thing that you say it amounts to, right? And so that would be sort of an open question, right? I think that today's Supreme Court maybe would side with Jerry, right? Like if it's in the trash, then it's trash, right? And it seems a little implausible to suggest otherwise, right? If you have to kind of go through these mental gymnastics to explain why it's not trash. On the other hand, there are people who think that we should have a much more open stance, right? That if it is possible that it's not trash, we should just say for now, it's not trash. And we'll wait until later in the lawsuit to decide whether it's really garbage, right? We'll go through discovery, we'll have a fact-finding process, maybe we'll have summary judgment, maybe we'll have a full jury trial on the question of whether this is garbage. So I just want to leave you all with one more question before I wrap up, and that is this. When Dean Schill asked if I wanted to do this webinar series, I said yes. And the very first thing I thought of with Seinfeld and civil procedure was about finality and statutes of limitations and preclusions, because I thought it was sort of a Seinfeld thing for there to be the following setup. Somebody observes something or experiences something that they feel is wrong, right? They feel somehow aggrieved, but they don't do anything about it in the moment, and they don't say anything about it in the moment. And then later it all comes out and somebody comes back and is basically like, you can't complain now. Why didn't you say anything back then, right? And I was going to use that to illustrate a whole bunch of these concepts that I have up here. But as I was going through the catalog, I had a hard time finding specific examples of those phenomenon, even though I felt like it was a really classic Seinfeld and also Curb Your Enthusiasm setup. So if you, in fact, have a better sense of this than me, I would love for you to tweet at me or send me an email. Let me know. Let me know anything else you think about any of the other points that I've made. I would love to hear other places where people think that there is actually civil procedure all over Seinfeld or any of your other television shows and movies as well. So at this point, I think maybe there's a few questions that I would be happy to answer.
Yeah, that was just fantastic. And as one of my friends said, like, we'll never think of civil procedure in the same way again, in a great way. So the first question is, is it really a voluntary choice of law when parties are not on equal footing? We're thinking of situations where user agreements put together by, say, Amazon or PayPal, they have provisions where the disputes have to be litigated in a particular place, and those are going to be advantageous to the business. And the consumer seems like they don't really have a choice. What do you think about that?
Yeah, so this is one of the most pressing questions today that kind of sits at the juncture between civil procedure and contract law, which is, what is the extent to which we can use contract to alter people's procedural rights or procedural positions? And what does it mean when many of these agreements are not what we would call arm's length negotiated transactions, where it's two businesses kind of hammering out an agreement, but instead it's what we would refer to as a boilerplate contract, right? It's hidden in all of that language. So I personally think that that's not great. I don't think that these agreements represent a lot of willful choice on the part of the consumer, right? The question of whether they're voluntary or not gets to kind of deeper philosophical questions about what voluntary means, and whether you're in a situation where you're assenting to all sorts of terms and conditions, right? And it's voluntary in the sense of, I understand that by signing this cell phone contract, or signing this, buying this airline ticket, is that I am agreeing to everything, and I am willfully knowing that I haven't read everything, but I agree to be bound by the terms anyway. But there's also some arguments that, quote, the market is reading it for you, right? I don't find those to be terribly convincing. But it's not just choice of law and choice of forum that have these provisions, right? You can also be taken out of the public dispute system altogether, right? So these days, I think you are lucky if the only thing that's in your contract is a choice of law clause or a choice of forum clause, because what's much more likely is that there is an arbitration clause and a clause that prohibits collective action within arbitration, meaning that if you have a dispute with your cell phone company, or any of these other big companies that you might be interacting with, and constantly clicking and saying like, I agree, I agree, I agree, I agree, that you have basically taken yourself away from the courts altogether, and you've agreed to arbitration. And by the way, the arbitration is in a forum of their choosing, where they are paying the people who are doing the decision making. So it's one of the most pressing concerns and procedures. And so while I think that it is technically voluntary in some very sort of abstract philosophical sense, I don't think it represents the sort of choice or choice making that is helpful for people who are really thinking about seriously navigating their procedural rights.
Great. So this next question has another Seinfeld reference in it, which I think is hilarious. And but it asks, it references the episode where Jerry has to beat the polygraph about Melrose Place. And the question is, does upon information and belief, is that another way of saying, the following is not a lie because I believe it? And much more generally, what does upon information and belief kind of mean,
Oh, that's such a great question. Upon information and belief. So first of all, in some senses, it doesn't really mean anything. It is a convention that's used in pleadings, although it is not, that exact language is not mandated. But what it represents is that, okay, so remember when I was talking about what's in a complaint, and I said that when a judge is deciding whether or not somebody can survive a motion to dismiss, right, whether they've stated a claim for relief, they have to take all of the facts in the complaint as true. So the next question is, what stops people from just lying, right? Like, why not just make things up to get in the door? And a lot of people think this way, right? Like, oh, I know I'm gonna find this out later, so I'll just say this now. So what upon information and belief means is that in this other set of rules that more or less governs lawyer conduct, and then a rule called Rule 11, which governs veracity in pleadings, that you have to have some reasonable basis for saying what you're saying. So what upon information and belief means is that you have a good faith reason for making the assertion that you're making. You might not know it to be true in a really certain sense, and you often don't have actual evidence of it. And that's very typical at the outset of a lawsuit. A lot of times the evidence that you need is just not available to you, right? So there might be a gap between what you know because you yourself are drawing reasonable inferences from conduct and what you can actually prove at the end of the lawsuit once you've gone through discovery. So upon information and belief is basically the lawyer / client's way of saying, I have a good faith reason for thinking this to be true, right? I'm not lying, I'm not making this up. And so what that means is that if later it turns out that you are just making things up and you really had no good reason to know or believe something, then you have not been truthful in your pleadings, right? So upon information and belief is just a placeholder for saying that you have a good faith basis for making that claim without having to go into that. Otherwise, when you have complaints, you would have like a million different rabbit holes that people go down to explain the basis for all of their claims. And that then complaints would get really big and complicated, and that wouldn't be so great.
Great. Yeah. So another question is, in the case of the bakery and the federal court filing comparison, if you have a ticket at the bakery, you're probably going to get waited on eventually. Does the same thing apply in federal court? Do you have to be waited on, or if you make a proper filing, and if so, are they allowed to just dismiss the case out of hand, or what are the kind of conditions there? And yeah.
That's a great question. It's actually a really complicated, in some senses, it's a really easy question. In some senses, it's a really complicated question. So the easy answer is yes, right? When you go to the court and you take a number, so to speak, someone has to do something. Now, most courts have a central legal staff that helps kind of sort through these things, either before they're assigned to judges or as they're assigned to judges, so that if it looks like there are real sort of genuinely non-meritorious claims, that can be kind of flagged, right? Judges can pick up on that, but someone still has to make a decision, right? If you have done all of the correct things procedurally, right? If you've gotten your summons, if you've paid the fee, or you were able to get a fee waiver because you're going in form of pauperis, someone has to do something. Now, a lot of claims can be dismissed very easily, right? So the judge will look at it and say, well, it looks like you're having a tough time, but you haven't shown me any law that's been violated, right? But it does have to be dismissed according to an order, right? They can't just do nothing. And in fact, it is an issue in courts, right? In federal courts in particular, but in state courts a lot more, which is, what do we do with really crowded dockets, right? What if it's the case that lawsuits are just sitting around with nothing happening for months and months and years and years? This is not supposed to happen on the criminal side because you have a constitutional right to a speedy trial, although I'm sure my criminal procedure friends can tell you all about the ways in which the speedy trial clock is, that has its own difficulties. But there's no constitutional equivalent on the civil side, right? There's no speedy trial clock that's ticking. So one thing that happened in federal court is that there was a statute passed in the early 90s that was a big procedural statute. It made a lot of changes and reforms to the federal courts. And one thing that it did was it introduced something called the 6-month list. And the 6-month list is exactly what it sounds like. It's a big list where every 6 months, judges have to sort of make a list of all of the cases that have been pending for a certain amount of time, and kind of explain like why they're still pending, right? And so a a lot of times there's a lot of good reasons why cases are still pending, right? Cases that are actually being litigated take way longer than 6 months to litigate. You know, a lot of times cases are pending because of non-prosecution. It's actually very common for people to file lawsuits and then just not follow up on it. And every once in a while, judges will kind of round those cases up and send off an order to show cause and say, like, unless you tell me that something's going on, I'm just going to go ahead and dismiss this lawsuit. So the 6-month list is supposed to kind of encourage judges by mere fact of disclosure to be aware of the cases on their docket and move things forward. There's actually been some interesting research showing that the 6-month list is not terribly effective, but yeah, it's a good question, right? If you take your ticket, something is supposed to happen. Federal courts are a little bit better about it than state courts, but you don't get to just kind of like not have anything happen.
Great, yeah. So one question that I have is, you know, so when George hears the rules from the deal, he kind of immediately knows that once there's the option to spend the night, he's like, oh, you went too far, right? You flew too close to the sun. That one's not going to work. And I wonder if they might have done better, because there's discretion there. They might have done better with picking an adjudicator. And so do you think that would have helped because of the standard? And then if they had, who would you have picked as an adjudicator? Who do you think they should have picked?
Wow, that's such a good question. Who would I have picked as an adjudicator? So first of all, it's a great question, right? Because it points out exactly what went on, right? They made a choice of law, but they didn't make a choice of forum, or they didn't choose a tribunal otherwise. And so that's a good point, right? Is that you're sort of like leaving it in question. Where does this dispute get adjudicated? I would say, oh man, if anyone from like all those years of Seinfeld, I mean, in some ways, the soup Nazi is a very decisive person, right? And that's kind of what you want in this situation, which is, you know, I joke, but there's actually a value in that. Sometimes the value of having an answer quickly is more important than someone having the right answer. But Newman keeps popping into my mind. I don't know why I would say that. Why would you want him deciding anything? And I think the reason I think Newman is that if you have made such a ridiculous deal, right, you deserve a ridiculous adjudicator, right? So there, by the way, there's no principle. There's no like maxim of equity that says like, when you come to equity with ridiculous hands, then you must be judged by ridiculous people. But you know, I guess that's my maxim of equity.
That's so great. And somebody else suggested Jackie Childs. One question.
Oh, well, that's actually, that's actually a good question, is whether you want another lawyer to be an adjudicator. And I will just sort of flag that for the webinar, that especially in international commercial arbitration, it's very common for prominent international litigation lawyers to also be arbitrators. And I will leave that to everyone else to think about whether that's a good idea, whether the people who are going to be the person adjudicating the situation should also be regular participants as litigants in the situation.
Right. And so another question that I think is super interesting is just in terms of meeting the standing requirements, what's easier, state or federal court?
Oh, meeting standing requirements? I mean, that's hard for me to answer because I am not an expert in the standing requirements of the courts of all 50 states. I mean, it's my gut reaction is that it's federal court, because the federal constitutional standing requirements, which apply to federal courts, not state courts, do tend to be a little bit more stringent, because they don't come directly from, for the most part, but they are related to Article 3 and the fact that the federal government is a government of limited and enumerated powers. And because state courts come from jurisdictions that are plenary jurisdictions, that it's a little bit easier. But I feel like now it's going to be on YouTube forever, like what I think about the relative standing requirements. So I will just put a big asterisk by my answer.
Great. Well, the last thing that many people pointed out was that Euban wanted to cut the bicycle in half between when in the thing between Elaine and Kramer. And so, you know, you're right. You make a crazy deal, you might get a crazy solution. That was just so excellent. Thank you so much.
Thank you. I really enjoyed this, and I look forward to hearing from anyone who is similarly interested.